9 justices, complete agreement, and every single retired person across all 50 states is about to feel the effects of what just took place inside the nation's highest court. This is not a partisan story. This is not a conservative versus liberal debate. This is a unanimous decision, meaning the most right-leaning justices and the most left-leaning justices sat together, reviewed the same evidence, studied the same legislation, and emerged on the other side in total agreement. That almost never happens in a court as politically divided as this one has been for many decades. A 9-0 ruling is not just uncommon, it is historic. And the fact that you likely have not encountered this yet is precisely why you need to stay right here until the very final word of this video. What the Supreme Court just determined reaches directly into the retirement security of millions of Americans who spent their entire working lives contributing to a system they were assured would be there for them. We are talking about Social Security benefits. We are talking about the money that older Americans count on every single month to pay rent, to buy groceries, to cover prescription medications, to keep the lights on. And this ruling changes the legal framework around how that money is protected, how it can be reduced, delayed, or denied, and what rights you now hold if the government attempts to interfere with what you are owed. Before this ruling, there was a quiet but growing pattern developing inside federal agencies that most retirees were never aware of. Administrative decisions were being made about Social Security benefits with almost no meaningful way for ordinary Americans to challenge them. The process was buried beneath layers of bureaucracy. The appeals were slow. The outcomes were frequently predetermined. Retired Americans who had been wrongfully denied benefits or who had seen their monthly payments reduced without clear explanation found themselves trapped inside a system that appeared designed to wear them down until they gave up. And many of them did give up because fighting a federal agency when you are living on a fixed income, when every single month matters, when legal costs alone can drain your savings, is not a battle most people have the energy or the resources to wage. That was the reality that existed before this ruling came down. And here is where the story of one ordinary American changed everything for every retired person across this country. There was a man, a retiree who had worked for decades, contributed to Social Security throughout his entire career, and reached retirement age expecting to receive exactly what he had been promised. Instead, the agency responsible for managing his benefits made a series of administrative decisions that reduced what he was rightfully owed. He challenged those decisions. He went through the internal appeals process exactly as he was supposed to. He followed every rule. He filed every required form. He met every deadline. And at every stage, the agency used its own interpretation of its own regulations to rule against him. The system was essentially grading its own work and giving itself a perfect score every single time. So he brought the matter to federal court, and then it climbed higher and higher until it reached the Supreme Court of the United States. And when those 9 justices examined what had happened to this man, when they looked at how federal agencies had been operating with nearly unchecked authority to interpret the laws governing Social Security benefits in whatever manner served the agency rather than the retiree, they did not split 5-4 the way the nation expected. They did not divide along ideological lines the way every other contentious ruling tends to do. They agreed, all 9, completely and unanimously. The foundation of what the Supreme Court decided comes down to a principle that sounds almost too straightforward to be the center of a landmark ruling. The principle is this: federal agencies do not get to be the final authority on what the law means when it comes to the benefits you are legally entitled to receive. For decades, something known as the Chevron Doctrine had granted federal agencies enormous power to interpret the laws they administered. What that meant in practice was that whenever there was any ambiguity in a law related to Social Security, the agency responsible for running that program got to decide what the unclear language meant, and courts were instructed to defer to that agency interpretation as long as it appeared reasonable, not whether it was accurate, not whether it was fair to the retiree, simply whether it seemed reasonable to the people inside the agency making the determination. Think about what that actually means for a moment. Imagine you have a contract with someone, a legitimate legal contract that states they owe you money every single month for the rest of your life. And then imagine that whenever there is any disagreement about what the contract means, that other party gets to serve as the judge. They get to interpret every unclear phrase. They get to decide every close question. And the court is instructed to go along with whatever they conclude unless it is entirely unreasonable. That is what retired Americans were living with before this ruling. That is the system that was operating while millions of people attempted to fight for benefits they had earned over a lifetime of dedicated work. The Supreme Court examined that arrangement and declared it could not stand. Courts are supposed to determine what the law says. That is their responsibility. That has always been their responsibility, going back to the earliest foundations of American constitutional law. When a federal agency makes a decision that takes money away from a retiree or reduces their monthly payment or denies their claim, and that retiree challenges that decision in court, a judge must now apply genuine, independent legal analysis, not automatically validate whatever the agency decided, not defer to the agency simply because the agency has experience running the program, but actually read the law, actually determine what it means, and actually protect the rights of the American citizen who is standing before that court asking for what they were promised. This is the shift. This is what a 9-0 ruling looks like when it lands in the real world of retirement security. And if you are currently receiving Social Security benefits, or if you are within 10 years of retirement, or if you have a spouse or a parent who depends on those monthly payments, this ruling is not an abstract legal development happening somewhere far removed from your daily life. This is the architecture of your financial security being rebuilt on stronger ground than it has stood on in many decades. Here is something that most coverage of this ruling is entirely missing. The impact is not identical in every state. Because Social Security Administration involves both federal regulations and state-level implementation in certain programs, the practical effect of this ruling on your specific situation depends partly on where you live. Some states have been more aggressive than others in using administrative interpretation to limit certain categories of benefits. Some states have larger backlogs of denied claims sitting in the appeals system right now. Claims that were decided under the old framework where agencies held all interpretive power. Those pending cases are now being viewed through a completely different legal lens. And in those states, the number of retirees who may now have legitimate grounds to reopen their cases, to challenge past decisions, to demand that a court actually examine whether the agency applied the law correctly, is significant. This is not a promise that every denied claim will be reversed. This is not a guarantee that every retiree who was shortchanged will automatically be made whole. What it is the opening of a legal door that was firmly shut for a very long time. A door that stands between ordinary Americans and the retirement security they spent their working lives building. And the Supreme Court just propped it open with a unanimous ruling that no future administration, no agency director, and no federal bureaucrat can simply disregard. You need to stay with this video because what follows is the portion that will tell you exactly what this means for your particular situation. We are going to walk through the states most directly affected. We are going to examine the categories of Social Security benefits where this ruling has the most significant impact, and we are going to provide you with a clear picture of what options now exist for retirees who were denied, reduced, or delayed benefits under the previous framework. The information in the next section of this video could be the most financially significant thing you hear this entire year. Do not go anywhere. Let us continue exactly where we left off, because the details that follow are the ones that transform this ruling from a headline into something you can genuinely use. We established that the Supreme Court unanimously dismantled the framework that gave federal agencies unchecked authority to interpret the laws governing your retirement benefits. Now, we need to discuss what that looks like on the ground in real states for real retirees in the specific situations where this ruling carries the most immediate and most powerful effect. Start with the states that have the highest volume of Social Security, disability, and retirement benefit disputes currently sitting inside the appeal system. States like Florida, Texas, California, Pennsylvania, Ohio, Michigan, Georgia, and Illinois carry enormous retiree populations. These are states where tens of thousands of benefit claims have been denied, reduced, or delayed over the past several years. Many of those decisions were made by administrative law judges operating inside the Social Security Administration itself. Under the old Chevron framework, when those decisions were challenged in federal court, judges were instructed to give significant deference to how the agency interpreted its own rules. That deference is now eliminated. Every one of those pending challenges and every new challenge filed going forward will now be evaluated by a federal judge who is required to make an independent determination about what the law actually says and whether the agency applied it correctly. That is not a minor shift. That is a fundamental rebalancing of power between the federal government and the American retiree, and it matters most in exactly the situations where retirees are most vulnerable. Think about what happens when someone reaches retirement age and applies for the Social Security benefits they have been contributing to for 30 or 40 years, and the agency responds by saying their benefit amount is lower than expected because of some technical interpretation of how their earnings record was calculated. Under the previous system, that interpretation was nearly untouchable in court. The agency decided what the rule meant, and the court was told to respect that conclusion. Under this new framework, a judge can examine that same earnings record, read the same statute, and independently determine that the agency calculated it incorrectly. And if the judge reaches that conclusion, the retiree prevails. Now, let us discuss the categories of benefits where this ruling has the sharpest and most direct impact. The first category is Social Security Disability Insurance, commonly referred to as SSDI. The denial rate for initial SSDI applications has been extraordinarily high for years. A significant portion of those denials come down to how the agency interprets the medical and functional criteria written into the law. Those interpretations have historically been granted enormous deference by courts. That deference is now removed. If you were denied SSDI benefits and you believe the agency misread the legal standard that applies to your medical condition or your functional limitations, you now have stronger legal standing to pursue that challenge in federal court than you have had at any point in recent memory. The second category is survivor benefits. When a spouse passes away, the surviving partner is entitled to certain Social Security survivor benefits based on the deceased spouse's earnings record. The rules governing these benefits are written in federal statute, but for years, the agency has had broad latitude to interpret edge cases, particularly around marriage duration, timing of claims, and coordination with other benefit programs. Under the new framework established by this unanimous ruling, those interpretations are no longer automatically protected from judicial scrutiny. If a surviving spouse was informed that their benefit amount was calculated a certain way because of the agency's interpretation of an ambiguous provision, a court can now examine that independently and reach its own conclusion about whether the agency was correct. The third category is retirement benefit timing and reduction rules. There are complex provisions in Social Security law that govern how benefits are reduced when someone claims early, how benefits interact with pension income in certain cases, and how benefits are calculated when someone has worked in positions not covered by Social Security for part of their career. These provisions have generated enormous administrative interpretation over the years. Some of those interpretations have cost retirees thousands of dollars annually. With the Chevron deference framework now dismantled, challenges to those interpretations stand on fundamentally different legal ground than they did before this ruling came down. Here is the part of this story that most coverage is entirely overlooking, and it is the part that connects directly to the long-term financial security of everyone watching this video right now. This ruling does not only affect people who are currently in a dispute with the Social Security Administration, it transforms the environment in which every future benefit decision will be made. Agency officials and administrative law judges inside the Social Security system now understand that their interpretations of the law are subject to genuine independent judicial review. That awareness alone changes behavior. When decision makers inside a bureaucracy know that a federal judge will actually scrutinize their work rather than simply defer to it, the quality and fairness of those decisions tends to improve. The accountability that this ruling creates is not just legal, it is institutional. It reaches into the culture of how these agencies operate on a daily basis. Think about what this means for someone who is currently 55 years old and planning for retirement within the next decade. The decisions that the Social Security Administration will make about your benefit amount, your eligibility, your claiming options will now be made inside a system where independent judicial oversight is real and meaningful. The agency cannot simply adopt the interpretation most convenient for its administrative purposes and rely on courts to approve it without question. Every significant interpretive decision now carries the weight of potential judicial scrutiny, and that scrutiny will be applied by judges who are required to read the law themselves, not simply accept whatever the agency declares the law to mean. Now let us address a misconception that spreads rapidly whenever a ruling like this comes down. Some people hear about a Supreme Court decision that limits agency authority and immediately assume it means the government is about to reduce Social Security benefits or cut program funding. That is not what this ruling accomplishes. This ruling does not reduce any benefit. It does not authorize any cuts. It does not give Congress or any administration new power to shrink the program. What it does is the opposite of that. It gives individual retirees stronger legal standing to challenge decisions they believe are wrong. It transfers interpretive authority away from the agency and toward courts that are constitutionally designed to be independent. For retirees, this is a protection, not a threat. There is also a practical question that many retirees and those approaching retirement are asking right now, and it deserves a straightforward and honest answer. If you had a benefit claim denied or reduced in the past, does this ruling provide you a path to reopen that case? The honest answer is that it depends on where your case stands procedurally and how much time has passed since the decision was made. Federal law has specific deadlines for challenging agency decisions, and those deadlines do not disappear because of a new Supreme Court ruling. What this ruling does is change the legal standard that applies to challenges that are currently pending and to new challenges filed going forward. For older cases, the path back is narrower, but not necessarily closed. There are legal mechanisms, including motions based on changed legal circumstances, that attorneys who specialize in Social Security law are actively exploring right now on behalf of clients whose cases were decided under the previous framework. What does all of this mean when you bring it back to the most important number in this entire story, 9-0? Every justice on a court that has been deeply divided on nearly every major question for years looked at the issue of whether federal agencies should have unchecked authority to interpret the laws governing your retirement security and said no unanimously, without a single dissent, without a single reservation significant enough to produce even a partial disagreement. The strength of that consensus is itself a message to every federal agency, every administrative law judge, every official making decisions about the benefits of retired Americans. The message is that the courts are watching, that the law means what it says, and what it says will now be determined by judges who are accountable to the Constitution, not by agencies that are accountable primarily to their own administrative convenience. If you have been contributing to Social Security your entire working life, if you are planning a retirement that depends on receiving what you were promised, if you have a parent or a spouse whose monthly benefit payment is the difference between stability and hardship, this ruling is the most significant legal development in the retirement security space in an entire generation. Share this video with someone who needs to hear it. Leave a comment below and tell us which state you are in and whether you or someone you know has dealt with a Social Security benefit dispute. The conversation happening in the comment section of this video genuinely matters, and every single comment gets read. subscribe, and turn on notifications, because the follow-up content breaking down exactly how this ruling applies state by state is already being prepared, and you do not want to miss it when it is released. 9 justices, 0 disagreement, 50 states affected, and a retirement system that just received a stronger constitutional foundation than it has had in decades. That is the story, and now you know.